Chan Chi-chuen議員。
Mr. Chan Chi-chuen, please ask your question. Thank you, Mr. President. Earlier, the Chief Executive Office, Xi's office, uploaded onto Xi's Facebook page a video clip featuring Xi himself and some other people singing together a karaoke song when attending a banquet, as well as photos of 2 types of buns and cakes of a cartoon character design recently bought by Xi when he visited the Hong Kong Brands and Products Expo. Some netizens have queried that the acts of uploading the video clip and photos may have constituted an infringement of copyright. It has been reported that Xi's office subsequently admitted that the prompt uploading of the video clip was undesirable and indicated that it had made retrospective payment of royalties to and obtained the relevant license from the Composers and Authors Society of Hong Kong Cash. In this connection, will the government inform this council? 1. Given that some creators have pointed out that the uploading of video clips featuring acoustic covers of karaoke songs onto the internet may involve 6 different copyrights, whether Xi's office has made payments of royalties in relation to the aforesaid video clip to copyright owners other than cash, if it has, of the respective amounts of such payments, of the amounts of royalties paid retrospectively by Xi's office to cash. 2. Given that Xi's office paid royalties to and obtained the relevant license from cash only after it had uploaded the video clip, whether the authorities have assessed if that uploading act has incurred any criminal or civil liabilities for infringement of copyright. Given that the Director of Intellectual Property has remarked that since CE is a public figure, the fair dealing exception for commenting on current events provided under the Copyright Amendment Bill 2014 may be applicable to the uploading act in question. But CE's Facebook page is not a news website, and the video clip lasting 1 minute and 9 seconds contains no content commenting on any subject of current events, of the specific justifications for the directors making the remark. Given that some netizens have queried that even the director has a problematic understanding of the amendment bill, of the measures adopted by the authorities to publicize the contents of the amendment bill so as to prevent members of the public from breaching the law inadvertently. And 3, whether Xi's office had obtained authorization from the copyright owners of the relevant cartoon character before it uploaded the aforesaid photos of buns and cakes, if it had, of the details. If not, whether the authorities have assessed if that uploading act has incurred any criminal or civil liabilities for infringement of copyright. Secretary for Commerce and Economic Development. Mr. President, I'd first like to explain a few basic concepts in copyright. Copyright is a private property right protected by law. Such a right is provided for in Articles 6 and 140 of the Basic Law at the constitutional level. Article 140 provides that the government shall protect the achievements and the lawful rights and interests of authors in their literary and artistic creation. The Copyright Ordinance, Cap. 528 Laws of Hong Kong, contains detailed provisions on how to define the existence of copyright and the vesting of rights and interests. Thus, as a matter of law, copyright owners have the right to determine whether to agree to the use of their copyright works by others and the conditions of use. It is common in real-life situations that users use others' copyright works in accordance with licensing terms and conditions. This is a common mode of economic activity which helps to achieve an important goal of the copyright system, namely providing economic incentives to creators through the legal protection of copyright, which in turn encourages creativity and dissemination of knowledge. In another common real-life scenario, a copyright owner may not have given any expressed consent or reached any licensing agreement with the user before the latter's use of the former's copyright works. However, if a consensus between the copyright owner and the user could be objectively derived from the copyright owner's overall conduct or from trade practice or custom, an implied license or acquiescence to allow such use could be legally established. Whether the user has any Legal liability would depend on whether the owner takes action against the user and the ruling of the court in any subsequent litigation. Another important concept in copyright laws is copyright exceptions. Copyright protection is not absolute. Users can use others' copyright works in the absence of the owner's consent under reasonable circumstances. This is important for freedoms of speech and of creation, which are also protected constitutionally. The existing copyright ordinance contains more than 60 provisions on copyright exceptions. The Copyright Amendment Bill 2014 proposes additional copyright exceptions to the ordinance. My replies to Mr. Chan Chi-chuen's questions are as follows. 1. In this case, the cover version of the song involves 2 layers of copyright works. 1. The melody and lyrics of the song, and 2. The musical recording of the background music. The making of a video clip of the singing of the cover version and the uploading of the clip involved the following rights of the 2 layers of copyright works. 1. Right of reproduction. The music industry may further divide it into a right of reproduction and right of synchronization, the latter of which refers to the right to merge the lyric or melody and musical recording with the visuals of the video clip. 2. Right of making available copies of copyright works on the Internet. The respective rights in the melody and lyrics are managed by the Composers and Authors Society of Hong Kong Cash and covered by a license. The C's office has obtained the license at the cost of $600 for 3 months from the date of the event. The respective rights of the musical recording belong to the producer. If the musical recording came from a released record, the respective rights would be managed by the record label and covered by a license. After the event, the C's office has made earnest efforts to identify the owner, including liaising with the organizer and the production company of the event that evening, as well as the company that releases the relevant sound or video recording products. The C's office has eventually been informed that the musical recording of the background music did not belong to the latter company. As such, it has not been possible so far to identify the copyright owner to obtain a license. 2. The license that the C's office has obtained from Cash is effective for 3 months from the day of the event. There is thus no question of legal liability for copyright infringement. As for the rights in the musical recording, the C's office would be pleased to pay the fee to obtain the necessary license if the copyright owner could be identified. On the day following the day on which the news was reported, without knowledge of the details of the case, the Director of Intellectual Property DIP made it clear at the beginning of her reply to media questions that what should first be considered was whether the consent of the copyright owners had been obtained. If that was the case, there would be no question of copyright infringement. When asked if there had been no licenses, the DIP said one might consider if the exceptions to the copyright ordinance were applicable. And legally speaking, the fair dealing exception for reporting current events under Section 39 subsection 2 might be applicable. When subsequently asked by other reporters about this exception, the DIP also explained its legal rationale. The DIP did not refer to the fair dealing exception for commenting on current events proposed by the bill. We note that some media reports on this issue, as well as the principal question above in this regard, are not accurate. There's no factual basis in the allegation that the DIP did not have a proper understanding of the bill. Regarding the possible application of 39(2) of the Copyright Ordinance, the legal considerations are whether the relevant act is reporting current events and whether the dealing of the relevant work is fair. The provision does not specify that this exception covers only reporters and news agencies and websites. On publicity and education, the government has been promoting the awareness of and respect for intellectual property in society. In respect of the copyright law, we agree that more publicity with particular emphasis in relation to common usage of copyright works on the internet may be carried out so that the public could have a better understanding of the relationship between the copyright law and our daily life. 3. We note that many merchants in the market are authorized by copyright owners to use copyright works, especially pictures, illustrations of cartoon characters in their decorations, to attract customers or to produce food products containing such pictures or illustrations for sale. It is also common for customers to take photos of these decorations and food products and upload them to online social platforms. From the perspective of copyright law, this may constitute use of others' copyright works. However, as mentioned above, so long as there is consent from the owners, including through licensing, implied licensing, or acquiescence, or it falls under any of the exceptions in the copyright ordinance, such acts would not attract legal liability. In reality, we are not aware of any legal action taken by copyright owners in respect of such acts. We believe that copyright owners are generally liberal with customers' online sharing of photos of food products containing pictures or illustrations of cartoon characters. Prohibition of such photo taking by customers is uncommon. This may lend support to the existence of implied licensing or acquiescence from a legal perspective. The C's office has not obtained authorization for uploading such photos in line with legal considerations and common practices. Thank you, Mr. President. Mr. Chan Chi-chuen. Mr. Deputy, in fact, the officials answering my question today shouldn't just be the Secretary for Commerce and Economic Development. The Information Coordinator and the C's office representative should be here as well. Because for the first part of my question, I believe Mr. Andrew Fong relayed this answer to Mr. Greg So. And had he not given you information, you wouldn't have been able to answer the question. For example, in the first part of your reply, you said that you already paid $600 to cash for a license of 3 months, and then after the event, the C's office has made earnest efforts to try to pay the fee to the relevant party. But it has not been possible so far to identify the owner. However, according to the IFPI's head, Mr. Fong, on a radio program, he said that apart from paying the fee to cash, you should also be paying the royalties to IFPI. So this is one version against another. So Mr. Greg, so you are unable to answer this question because Mr. Andrew Fong hasn't answered you whether C's office has paid IFPI or not. And then part 2 of the reply, you said that the C's office would be pleased to pay the relevant copyright owner the fee to obtain the necessary license after the event. That is to say, you are still unable to identify all the relevant copyright owners. However, use of copyright works without authorization could incur criminal or civil liability. Can any ordinary citizens use the same excuse and use the copyright work first without getting any authorization, and if nobody takes action against the person, there is no need to pay a fee? As the head of government and as a C's office, this is infringement of copyright. And what about the ordinary citizens? Mr. Deputy, I ask for a quorum count.
局長。
Secretary.
主席，回應翻陳志全。
Mr. Deputy, to respond to Mr. Chan Chi-chuen's question, the first part of his question was about whether the CE had privileges and that he could apply for a license afterwards. And in that regard, there is no distinction between the chief executive and any member of the public. The chief executive doesn't have any privilege. Now, in relation to the copyright owner and the user, the licensing agreement is a private contract between the two. Therefore, the valid period of the license, the amount of the fee, would be set by both parties. And the license could also cover future acts. There is no particular restriction as far as the law is concerned. So there is no privilege on the matter of applying for the license after the event. In fact, in relation to Part 2 of Mr. Chan's follow-up question, the answer is very clear from Part 2 of my reply. That is, the CE's office has obtained a license for the lyric or musical recording, and there is no copyright infringement in this regard. And as mentioned in my main reply, it's very clear that the CE's office has had tried to contact the production company releasing the relevant sound video recording products, and eventually the CE's office has been informed that the musical recording of the background music did not belong to the latter company, and if the copyright owner can be identified, the CE's office would be pleased to pay the fee to obtain the necessary license. Secretary only repeats his answer. He hasn't answered my question. My question is this. Well, in the CE's case, it was only after the incident happened, when the scandal was exposed, that he went to pay a fee, whether this amounted to any civil liability. Well, let me repeat. Maybe Mr. Chen didn't catch me clearly. Well, the licensing agreement is set between two parties, and they can decide on the licensing period and the fee. There is no special restriction as far as the law is concerned. So, Hon Kwok. Mr. Deputy, well, in the Secretary's reply, he mentions that the contracting period may be very long and that the CE has no privilege in this regard. But isn't it strange when it was uploaded, hadn't it occurred to you that there is this problem? If it is not exposed, if it had not been exposed, then you would not have gone to try to pay a fee to anybody. Well, in fact, I think Part 3 of the reply is really ridiculous. In relation to pictures or illustrations of cartoon characters on food products, well, the CE has uploaded the photos. He was being complacent. Well, but has a license been sought from the copyright owner? And you also talk about acquiescence. Well, this is ridiculous. From a legal perspective, you say that this may lend support to the existence of implied licensing or acquiescence. I think this is arguable. I don't think people here understand. Mr. Wong Yuk-man, your question is? My question is clear. When you uploaded the relevant photo online, in relation to the cakes and buns with cartoon characters design, this is in line with common practices. This is wrong. Even if this is not wrong, it is still arguable. How can you answer like that? And also, Mr. Wong Yuk-man, please be seated. You asked a question. Please be seated. I will ask Secretary to answer. No, he didn't catch me clearly. Don't stop me. Mr. Wong Yuk-man. Well, did you ask Hello Kitty's copyright? Mr. Wong Yuk-man, please be seated. Mr. Wong Yuk-man, if you don't sit down, I would think that you are not behaving yourself. Secretary. Mr. Deputy, when I answered Mr. Chan's question, I already said that for license, it has a retrospective effect, so it's clear. The CE's office earlier also responded to the media inquiries. The chief executive, on the invitation at the event, went on stage to sing with guests. Mr. Wong Yuk-man. Mr. Wong Yuk-man. Secretary. Mr. Deputy, well, the CE's office already responded that evening the CE went on stage ad hoc to sing with guests on invitation, and the prompt uploading of the video clip was not desirable. And the CE's office afterwards had also made earnest efforts to obtain the relevant licenses. Mr. Martin Liao. Mr. Deputy, the Copyright Amendment Bill is very controversial. It is quite complex. So the government should have made adequate preparations. However, copyright also covers a very wide scope. On the payment of fees, there may be different systems. My question is whether you can whether the government can discuss with the copyright associations to set up a simple regime for the use of copyright works. For example, whether it is possible to set up a registration system for copyright works, not under the government, so that there is so that one can easily refer to the register for copyright works, and whether a fixed tariff system can be introduced for the payment of fees for use of copyright works. Secretary, thank you, Mr. Martin Liao, for your question and suggestion, which is very good. We understand that the existing copyright regime still has room for improvement to further facilitate users. In fact, we understand that based on behavioral changes among users, licensing agencies have set up platform for the enactment of agreements so that users can use copyright works without prior license. And we have also reflected the views of netizens to these licensing agencies for them to explore measures or mechanisms to facilitate users in applying for use of copyright works. And in the past, there have not been any claim of civil liability against individual users or ordinary members of the public by record companies. But I understand the concern, and we've also reflected this suggestion from Mr. Liao to them as a system, a mechanism set up would facilitate users in getting licenses easier, and it will also help promote the copyright regime. Mr. Martin Liao. What about fixed rates? What about fixed rates? Is it possible to try to set fixed rates of fees? We need to consider whether this would go against other pieces of legislation. We need to explore this idea further. However, if there is a more expedient and convenient system, it would facilitate the users' use of works and the promotion of the development of the industry. Mr. Tony Chair. Mr. Deputy, the member asking this question cited the incident of chief executive singing with others when attending a banquet and uploading photos of buns and cakes of a cartoon character design onto Facebook. And this, as a result, there is a discussion on copyright infringement. But I think in reality, many members of the public may have done the same. We need to avoid causing a social divide and misunderstanding. Apart from what has been said in the Secretary's main reply, that is, apart from striving to raise or promote the awareness of and respect for intellectual property in society, I agree with Mr. Liao's suggestion. I want to ask the government if the government will discuss with the relevant copyright organizations, because I'd like to know whether the government will prepare guidelines to clarify things, because there may be misrepresentations by some, causing unnecessary misunderstanding in society. So I want to know if you will do that, or at least will the government consider it, so that government officials will have a better idea, because you need to attend publicity activities. Secretary, I agree, because the copyright law has been developing in the international arena. It has become more and more complex. For example, it involves exemptions or exceptions, as mentioned, and it's a very complex piece of legislation with international standards to meet, and that is why we need to do more publicity and public education, so that the public would have a better understanding on how to meet the requirements. And that is why we need to step up publicity and public education and the preparation of guidelines. The Intellectual Property Department annually spends $8 to $9 million on public education publicity efforts, and we also regularly review the relevant initiatives to better meet the objective of letting the public understand the law.
Question number 5, Emily Lau. Acting President, it has been reported that 5 Hong Kong people who are shareholders or employees of the Causeway Bay books went missing, one after another, during the period from mid-October last year to the 30th of last month. The first person, the subsequent 3, and the last one were last seen in Thailand, the mainland, and Hong Kong respectively, before they went missing. Moreover, it has been reported that the wife of Mr. Lee Bo, the last missing person, received 2 calls from Mr. Lee to assure her of his safety, and the displayed caller number was a Shenzhen phone number. Subsequently, an associate of the bookstore also received a handwritten fax purportedly issued by Mr. Lee saying that I have returned to the mainland, using my own way to work with authorities concerned in an investigation. On the 6th of this month, the editorial of the Global Times, a state-run newspaper of the mainland, stated that powerful agencies across the world generally have their own ways to circumvent the law and make a person under investigation to work with them, so that they can proceed with their work without crossing the bottom line of the system. Acting President, the strain of incidents of people reported missing have aroused grave concern among people from various sectors of society. In this connection, will the executive authorities inform this Council, 1, of the actions to be set out in detail taken by the authorities since the first reported missing incident happened 3 months ago, to locate the whereabouts of those 5 missing persons and ensure their personal safety? 2. Given that the mainland public security authorities and the Hong Kong police have established a reciprocal notification mechanism regarding the detainment, arrest, or unnatural deaths of their residents in the territory of the other party, whether Hong Kong police have taken action under that mechanism in respect of the aforesaid missing cases, if Hong Kong police have, of the details, and whether, apart from the information announced by the public security authorities and official media on the mainland, HKP have received any information on the 5 missing persons as notified by the mainland public security authorities. If Hong Kong police have received such information, of the details. And 3, whether they have verified if the 5 missing persons were taken to the mainland by a powerful agency using means circumventing the law to make these persons work with it in an investigation, as mentioned by the aforesaid editorial of the Global Times. If they have verified and the result is in the affirmative, whether they have assessed if the action taken by the agency has contravened the principle of one country, 2 systems, and Article 28 of the Basic Law, which stipulates that no Hong Kong resident shall be subjected to arbitrary or unlawful arrest, detention, or imprisonment, arbitrary or unlawful deprivation or restriction of the freedom of the person shall be prohibited. Secretary for Security. Mr. Gary Fan, call for quorum.
保安局局長。
Secretary for Security, Acting President. My reply to the Honourable Emily Lau's question is as follows. 1. The Hong Kong SAR government attaches great importance to the cases of missing persons associated with the bookstore in Causeway Bay and fully understands the concerns of the community. Among the 5 persons who are suspected to be missing, 4 are Hong Kong residents. The police have received reports at different times that these 4 persons are missing. The family of one of the missing persons has also sought assistance from the Immigration Department, and the Immigration Department has already provided practicable assistance in accordance to the wishes of the family. As regards the other missing person, he is not a Hong Kong resident and not a holder of a Hong Kong identity card. The police have also not received any report that this person is missing. With regard to the above-mentioned missing person cases, the police have already commenced proactive and comprehensive investigation in an attempt to understand the circumstances, background, and the cause of the event of the missing persons. The police are also proactively gathering evidence and looking for clues from various sources, including closed-circuit television footage, etc. The police's investigation also covers the locations where the missing persons might have been, according to the informants. Currently, the relevant cases have been consolidated and are being handled by the Regional Missing Person Unit of Hong Kong Island of the Police, with the support of the Regional Crime Unit of Hong Kong Island. During the course of investigation, the police have been maintaining contact with the families of the 4 missing persons who are Hong Kong residents. The police have also informed the families of the investigation progress and answered their questions. At the same time, the police have set up a 24-hour hotline, 6764-4385, to facilitate provision of information related to the cases by members of the public. I would like to appeal to anyone who has any information which might assist the police in following up the cases to contact the police as soon as possible. During the course of investigation, the police have been seeking assistance from relevant mainland police cooperation units. In the evening of the 18th of January, the police received a reply letter concerning one of the missing persons, Li Bo, from the Interpol Guangdong Liaison Office of the Guangdong Provincial Public Security Department, stating that having understood that Li Bo is in mainland. Also enclosed in the reply is a letter from him addressing to the relevant government department of the Hong Kong SAR government. The content of this letter is similar to the one which the media reported that he has written to his wife on the 17th of January. The police have contacted Mrs. Lee, who confirmed that it was Li Bo's handwriting in the letter. The police have already written to the Interpol Guangdong Liaison Office of the Guangdong Provincial Public Security Department on the 18th of January, requesting to meet with Li Bo and further understand the situation of the incident. The Hong Kong SAR government is concerned about the rights and personal safety of Hong Kong residents in or outside of Hong Kong. The police will continue to spare no effort in the investigation. However, the police could not disclose all the case details so as not to affect the investigation. 2. Since the 1st of January 2001, the Hong Kong SAR government has, by way of an administrative arrangement and on the basis of mutual respect for the relevant laws of both sides, put in place a reciprocal notification mechanism with the mainland in respect of cases involving unnatural deaths and imposition of criminal compulsory measures on residents from the other side, so that notification could be made as soon as practicable. Upon receipt of notification from the mainland authorities, the Hong Kong SAR government will inform the family members of the persons concerned as soon as possible, so that the latter can consider whether to engage a lawyer or to seek other assistance through the Hong Kong SAR government. In this respect, the mainland public security authorities and other relevant authorities have been offering assistance and cooperation, and the reciprocal notification mechanism has also been serving its purpose. Since the operation of the mechanism in 2001 to the end of December 2015, over 12,000 notifications involving more than 9,400 Hong Kong residents were made by the mainland authorities to the Hong Kong SAR side. In addition, the Hong Kong police have been maintaining a police cooperation mechanism with relevant mainland counterparts parts. Under the mechanism, if one party requires the assistance of the other party to conduct investigation, the requested party may gather information relevant to the case through legal means and provide such information to the requesting party. When the requesting party makes a request for assistance, it must give prior notification to the requested party and explain clearly the nature of the case and the scope of the assistance sought for the investigation. It will then be for the law enforcement officers of the requested party to undertake the investigation work in accordance with the law. When conducting such cooperation, any law enforcement actions must only be taken by the law enforcement agencies in accordance with the law. Under no circumstances can police officers of either side take enforcement actions in the territory of the other jurisdiction. Under the above mechanism, the two sides could communicate with regard to various cases or matters, and both sides have received assistance from the other side as well as information. In the past, a number of cases have registered progress or have been solved through these mechanisms. As I mentioned earlier, in respect of the missing person cases, the Hong Kong police have received a reply from the Interpol Guangdong Liaison Office of the Guangdong Provincial Public Security Department. The police will continue to follow up on the cases with the mainland authorities and request for information on other relevant missing persons. 3. Since Hong Kong's return to China, the Hong Kong SAR government has all along been dealing with matters relating to the Hong Kong SAR strictly in accordance with the principle of one country, two systems and the Basic Law. The Basic Law only authorizes Hong Kong law enforcement agencies to enforce laws. Law enforcement agencies outside of Hong Kong, including law enforcement agencies of the mainland and overseas, do not have the authority to enforce laws in Hong Kong. If law enforcement officers of non-Hong Kong jurisdictions take law enforcement actions in Hong Kong, this will contravene Hong Kong laws and is unacceptable. Except properly permitted under the laws, we shall not tolerate any unauthorized law enforcement action by anyone or any organization. For any suspected case of infringement, we will conduct full and thorough investigation. I will not comment on reports or comments by individual media, irrespective of whether they are local or non-local media. Since the police's investigation of the cases is still ongoing, in the absence of a full grasp of the facts, it is not appropriate for me to make any speculation. Article 28 of the Basic Law states that the freedom of the person of Hong Kong residents shall be inviolable. No Hong Kong resident shall be subjected to arbitrary or unlawful arrest, detention, or imprisonment. Arbitrary or unlawful search of the body of any resident or deprivation or restriction of the freedom of the person shall be prohibited. The Hong Kong SAR government will, as always, continue to resolutely safeguard the rights and freedoms of Hong Kong residents in accordance with the law. Thank you, President. Ms. Emily Lau. Acting President, 5 missing persons in relation to the Causeway Bay bookstores. It's been 3 months down the road. The government said it's been concerned and is doing its best. 4 of them are Hong Kong residents, and their cases have been reported to the police. And we know only a little bit about Li Po, and we don't even know his whereabouts. And also Liu Po, Lam Wing-kei, and Cheung Ji-ping. We know nothing about them. And you said that the police is doing its best. How can the police or the administration reassure Hong Kong people that you are doing your best to safeguard the freedom of person? As what the Secretary said, if non-Hong Kong law enforcement officers are here to enforce the law and take away people, it is going against the Basic Law. But it seems that you are not doing enough. Now, President, there have been newspaper reports saying that last week, the Meng Jianqu, the Secretary General of the Political and Legal Affairs Commission, went to Shenzhen and he did some coordination work there. Did the administration send someone there to check out on the situation, to go to Shenzhen and Beijing and tell Hong Kong people that you are actually defending Hong Kong people's rights and that the Basic Law will not be under threat? The SAR government has been acting in accordance with the one country, two systems principle and acting in accordance with the Basic Law and Hong Kong laws. We all know that the police have received reports of the several missing persons, and the Regional Missing Person Unit of Hong Kong Island has taken action, and they have seen the family members and collected information. And as what I said in my reply, through the mechanism set out there, we've tried to seek assistance from the relevant mainland authorities. Thank you. For the 4 missing persons, well, on the night before last night, we received information relating to one of the missing persons, and we are following up on the other 3 persons. We will continue to work hard, and we are expecting a reply from the relevant mainland authorities. In the past several weeks, the local media and overseas media are highly concerned about the incident. They have made various reports. We have read those reports, but then we will not comment publicly media reports and the background of the reports and so on. What we do is one thing. We would try our best to collect evidence, and we appeal to anyone in Hong Kong who has the information on these 4 persons. They can inform the police as soon as possible. We welcome any pieces of information. I'm not asking him to comment. I'm asking him whether he has gone to, he will go to see Mr. Meng Jianzhu, whether he will go to talk to the central authorities. Hong Kong people are very scared because 1 country, 2 systems will break down soon. We've got information from the mainland authorities on 1 person. We have also sent a letter to the Interpol Guangdong Liaison Office of the Guangdong Provincial Public Security Department asking to meet with Li Bo so that we can collect further information. Dr. Joseph Lee. Thank you, Acting President. I didn't expect that I can ask him so soon. In the canteen, I heard what Mr. Lai said. In your reply, you haven't mentioned something. The facts are obvious. The mainland authorities confirm that he is in the mainland, and he hasn't got any exit record. So if someone goes out of Hong Kong illegally, is he breaking the law? Well, but the gist of my question is not this. Rather, if someone goes out of Hong Kong illegally and go to the mainland, do we have a strong agency or a strong police force to take him back to Hong Kong? Do you have a shampoo boat or what to take him back to Hong Kong? Well, quiet, please. Secretary, Dr. Lee, to my understanding, there is no powerful agency among the various government departments or bureaus in Hong Kong. The various government departments carry out our public duties in accordance with Hong Kong laws. And outside of Hong Kong, we don't have any authority to enforce the laws. And this is the same for other law enforcement agencies outside of Hong Kong. Any law enforcement agencies outside of Hong Kong cannot enforce their laws in Hong Kong. Now, as for Mr. Li Bo's case, how come that he returned to the mainland? This is something that the police have to understand and investigate into. Say, for example, if we can meet with Mr. Li Bo, we may be able to get further information, and we may be able to collect further information on the point you mentioned. Well, the gist of my question is not this. Since a Hong Kong resident goes out of Hong Kong illegally, I don't know whether he is breaking the law. So, Secretary, will you be asking the mainland authorities to send him back or repatriate him to Hong Kong? I don't think your question is like what you said. You asked whether there is a powerful agency within the Hong Kong government structure. Ms. Claudia Mo.
One of the safest cities in the world. So it's so very ironic that the Hong Kong person can be disappeared, quote and unquote, from Hong Kong as such. C.Y. Leung has tried very hard, has been trying very hard to play this down as some sort of ordinary crime. But the fact that even the Chinese foreign minister would bother to open his mouth on this issue tells you there's something very officially, politically involved in Beijing. Now you, as a political minister, you should be held politically accountable over this whole saga. I wish you would agree, right? My question is, have you actually provided extra protection to those involved in this whole business, especially Mrs. Li Bo, or anyone else that might be considered linked in this incident, and to help make sure the person or persons wouldn't become the next victim, the 6th or the 7th victim? Thank you.
Thank you, Acting President. If the police has conducted any assessment and feels that a certain person is under threat in terms of his safety, personal safety, then the police will discharge its duty to ask whether this person needs protection by the police. Now, if anyone asks for protection from the police, stating his or her reason and saying that his or her personal safety is under threat, the police have established procedures to consider whether to provide protection in view of the circumstances of the individual. Ms. Mao mentioned one particular person, but I can tell you that the police have prescribed attitudes and principles in dealing with the matter you mentioned. Now, Ms. Claudia Mo mentioned one particular individual. Now, but then, well, for safeguarding personal privacy, I'm sorry that I cannot tell you whether she has raised this request. But for on the police's part, in dealing with whether to give protection to an individual to uphold the personal safety, we will adopt the same standards, and the police will protect freedom of the person in Hong Kong in accordance with the law.
To my question.
局長有冇補充？
我相信我講得好清楚啦。
Any supplement, Secretary? I think I have made myself very clear. The answer is obvious. So in the course of investigation, if the police will do it, now if there is the person who requested it, then the police will do it. Well, Ms. Mo, please sit down. This is not a debate. Secretary? Without my permission, members should not speak. Secretary, I think I have made myself clear. I can't give you the details of the case, but our principle is that for whoever who raises the request that his personal safety is under threat, then we'll give protection. Mr. Yu Si-wing. Thank you, Acting President. In the second part of your reply, you said that on the basis of mutual respect for the relevant laws on both sides, you have put in place a reciprocal notification mechanism, and you have also put in place a police cooperation mechanism. So, Secretary, what is the difference between these two types of mechanisms, and under what circumstances will the SAR government activate with the relevant authorities such mechanism? We're talking about two mechanisms. Reciprocal notification mechanism, that's one that came into effect on the 1st of January 2001. This is an administrative arrangement made on the basis of the mutual respect for the relevant laws of both sides, and that will tackle cases where there has been an imposition of criminal compulsory measures on individuals, and notification could be made as soon as practicable. So they cover Hong Kong residents and also residents subject to the imposition of criminal compulsory measures. So these are the two elements for this mechanism. As for the other mechanism, police cooperation mechanism, well, that also covers what is covered under the reciprocal notification mechanism. But the scope is much wider, covers other matters as well. So we will be cooperating with each other. That would be the kind of collaboration similar to the Interpol's. Thank you, Chairman.
Last question seeking an oral reply. Mr. Frankie Yick. The government is studying the introduction of quality taxi service to be operated under the franchise model with a view to improving the current situation that taxi service varies in quality, which is caused by the highly scattered ownerships of taxi licenses and management responsibilities of taxis. Some members of the taxi trade have conducted surveys on taxi service with findings showing that respondents generally hope for improvements in the ways of hailing taxis and the service attitude of drivers, and they are in general willing to pay up to 30% more in fares for better taxi service. Those members of the trade are worried that the direction of the government study deviates from public expectations. In this connection, will the government inform this council, 1, of the considerations based on which the authorities will decide whether or not to introduce quality taxi service, and the criteria to be adopted for determining the relevant details, including the number of franchises, vehicle types, compartment facilities, and restriction on vehicle age, whether they have studied if the introduction of quality taxi service is the only solution to the current problem that taxi service varies in quality. If they have studied and they have done the study and the outcome is in the affirmative of the relevant justifications. 2, as the authorities suggest that any company holding a quality taxi service franchise be required to maintain an employer-employee relationship with its drivers, and the drivers concerned will hence be covered by the protection of the current legislation related to labor rights, such as the employment ordinance, the minimum wage ordinance, etc. Of the reasons why the authorities have proposed to add a franchise term to additionally require the franchise company to properly handle matters on drivers' remuneration, such as to ensure reasonable protection of drivers' benefits and interests, whether they have assessed if such a proposal constitutes overregulation and violates the principle of free market operation, and 3, as some taxi groups have now formed their own fleets to operate taxi service and have set the standards of service level, drivers' work attitude, reward and punishment system, as well as vehicle quality for fleet members to follow, whether the authorities will consider first keeping this situation in view for a period of time to ascertain if such an operation model can address the public calls for improvement in the quality of taxi service before deciding whether or not to implement quality taxi service, if they will, of the details, if not, the reasons for that. Thank you, Mr. Deputy. Secretary for Transport and Housing. Mr. Deputy, call for quorum. Mr. Gary Frank has made a call for quorum.
運輸及房屋局局長。
Secretary for Transport and Housing. Secretary for Transport and Housing. Mr. Deputy, my reply to the various parts of Mr. Frankie Yick's question is as follows. In recent years, the number of complaints relating to taxi service has increased rapidly from around 6,200 complaints in 2005 to around 10,000 complaints in 2014. The majority of the complaints were about refusal to hire, cherry-picking of passengers and poor service of taxi drivers. Improvement of quality of existing taxi service is a common request from the public. In response, some members of the trade are actively proposing some improvement measures. The government welcomes the trade's effort. Meanwhile, there is community's demand for point-to-point transport service of better quality and high fares. In this connection, the government is studying whether to introduce premium taxi service while enhancing the regime for approving and regulating hire cars, including ways to facilitate the entry of new service providers into the hire car market. We hope that by working on all the three areas together, the passenger demand on enhanced point-to-point transport service will be more comprehensively met. The government is studying the introduction of premium taxis through a franchise model, given the limitations of the existing taxi operation model in ensuring the overall long-term quality of taxi service. At present, some 18,000 ordinary taxi licenses have been issued, and they are all permanent in nature. These licenses have been issued without any conditions directly related to service quality. As such, we cannot impose any penalty against unsatisfactory services through the license conditions. Regulation of taxi services can only be carried out by enforcement actions under the Road Traffic Ordinance and its subsidiary legislations. Yet, the effectiveness of enforcement is subject to constraints in respect of the high threshold for prosecution and gathering of evidence. Moreover, the ownership of ordinary taxi licenses is scattered. There are over 9,000 license holders. Taxi owners and drivers do not usually have any employer-employee relationship. Incomes of taxi drivers are not directly related to their service quality. Thus, there is a lack of an incentive mechanism to ensure drivers' service quality. The service quality varies as it depends on the willingness or performance of individual owners or drivers. Premium taxis are introduced to provide a passenger choice other than ordinary taxis. This helps improve the taxi service and meet the community's demand for diversified services. Through a franchise model, the granting of time-limited franchises to a few companies to operate premium taxis will enable the government to set service standards and monitor the operator's performance through franchise terms. Operators will have to maintain an employer-employee relationship with their drivers. Drivers' performance will be monitored and managed centrally by operators. Moreover, operators will have to be of a certain business scale in order to benefit from economies of scale. Regulation of public transport services through franchise or similar regime is not a new idea. The most noteworthy example is the franchised bus service. The government is examining in detail other operational issues under the franchise, such as the number of premium taxis, vehicle types, compartment facilities, restriction on vehicle age, fare structure and level, etc. When determining the number of premium taxis, we will review the overall supply and demand of taxi service in Hong Kong, communities' demand, operating environment of the taxi trade, and traffic impact, etc. This is to ensure an orderly implementation of premium taxis and to continue to maintain reasonable competition and long-term sustainability of various public transport services. As premium taxis will be a kind of public transport service, the government, when setting the fare level, will carefully strike a balance between the higher operating cost to be borne by operators for better service quality and affordability of the target passengers. We will also study in detail how to adjust the fares as and when necessary. When setting service standards, we will canvass views from the public and the trade, as well as make reference to the experience of other places. With regard to the rights of drivers, the vast majority of ordinary taxi drivers are currently self-employed. Their income varies mainly with the fluctuation in patronage fares and rental expenses. For premium taxis, the future operators will have to maintain an employer-employee relationship with their drivers under the franchise and thus be regulated by the Employment Ordinance and other ordinances relating to employees' rights. Drivers' rights will be protected as their remuneration and fringe benefits will be properly handled. It is worth noting that the driver's remuneration will become one of the operating costs. As such costs will be taken into account when the government considers fare adjustment for premium taxis in future. Some members of the taxi trade have formed their own fleet to provide hire-as-a-whole service for passengers. That is a different ordinary taxi service with fare to be agreed between parties with a view to enhancing their operation and service quality. Meanwhile, as far as we know, some members of the trade are also preparing to launch a taxi-hailing mobile application that can be used by all ordinary taxis in Hong Kong for passengers' convenience. The government welcomes such effort. The Transport Department will continue to liaise closely with the trade to assist them in implementing various measures for enhancing taxi service. We trust that the trade's effort in enhancing taxi service will complement the government's plan to introduce premium taxis and enhance high-car service, thereby improving the point-to-point personalized transport service in Hong Kong substantially and providing diversified choices for the public. We plan to brief the Legislative Council panel on transport on the progress of the study on the introduction of premium taxis in mid-2016 and will strive to complete the study in the third quarter of the year. If it is confirmed that the introduction of premium taxis is feasible, we will immediately proceed with the necessary legislative amendments for early implementation. Thank you. Mr. Frankie Yick. Secretary, I question that you're using franchise as a means to regulate taxi service, and you think is an effective means, but I question that. Well, I'm sure there can be a debate later on, but I'm going to submit to you our views in writing later on. In the main reply, Secretary, you pointed out that the Bureau understands the taxi trade is trying to respond to the public demands for service quality. So they've already started some work on their own. They have started the development of a taxi hailing mobile application that applies across the territory. And also there is a training program to train the service attitude of taxi drivers. And there will also be reward and penalty scheme under the taxi hailing app. Please come to your question. I'll be quick, Mr. Deputy. And there will be various different types of taxis to provide different services. So you can see the trade is working very hard to improve its service. So, Secretary, would you first allow the trade some time to implement the improvement measures that I just measured? Will you observe if they are able to respond to the demands of the public in relation to taxi service before you consider the introduction of other forms of premium taxi services? Secretary. At the end of last year, we informed the panel on transport that we're going to introduce premium taxi service, and we are going to also introduce various regulation measures. Well, that's after thorough consideration that we've come up with these suggestions. Now, we heard a lot of views from the public about taxi service. There were strong demands, actually. And the public would like more choices in relation to point-to-point personalized transport services. For existing taxi drivers and owners, they have formed themselves into groups, and using their own means, they try to improve service. We welcome that. We hope that they will continue to do that. But it doesn't mean that we must not respond to the different demands of the community, because the public would like more choices. So we are not just talking about the feasibility of introducing quality service, taxi service. We're also talking about improving the current car hire services. We would like to have more forms of point-to-point personalized transport services for the convenience of the public. Mr. Yu Si-wing. Thank you, Mr. Deputy. Over 10 years, we've seen increasing number of complaints about taxi service, and that does affect the reputation of Hong Kong substantially. The government is now planning to introduce premium taxi service. Are you going to introduce some sort of a licensing scheme? with a view to improving service on the whole. I think the intention is good. But in paragraph 3, you pointed out that there are now 18,000 ordinary taxi licenses already in Hong Kong. If you issue more new licenses, it will only lead to more competition in the trade, and it will add to the pressure add to traffic pressure. So you are considering introducing premium taxi service. Well, I think Mr. Yick should try to listen to the views of, as Mr. Yick said, you should try to listen to the views of the trade, because they are already making effort to adjust their service. They may be able to offer service, quality service. Mr. Yu, please come to your question. Now, the government is also considering further improving the licensing arrangements for car hire services. Well, I hope you will consider that very carefully. I understand some companies have waited a year to get a license. They still haven't got it. So for such companies applying for hire car licenses, could you streamline the procedure so these companies could also provide a better quality service? Secretary. Now, after study, if the government believes it's feasible to introduce premium taxi service, Mr. Yu asked how we can ensure there will be a reasonable or healthy competition. Well, I agree that's important. That's why in the main reply I said that in future when we're to introduce premium taxis, we have to decide on the numbers, and we have to work out other details as well. And most definitely, in considering, we will give a comprehensive consideration of point-to-point personalized transport services in Hong Kong. We make sure there is proper competition, and then we will make sure that all the services will serve the intended groups of passengers. And we also want the current taxi services to be improved as well. For premium taxis, we're not doing it by a licensing system. It would be by a franchise system. So it's because with licenses, you can't retrieve the licenses. Licenses can change hands freely. But with franchise, then there won't be such a problem. And on improving the regulation regime and so on, now we'll see whether we could move with the times in vetting applications and the criteria go by, and we will see what the demands are for luxury car hire, for instance. Mr. Michael Tan. Mr. Deputy, in the past 10 years, there's been a substantial increase in the number of complaints against taxis. Of course, the Secretary knows that. And from 700 cases of refusal to hire, it's gone up to over 2,000, 3 times more. And excessive charging of fares, also that's a problem. Now the police has been trying hard to carry out undercover operations to stem out such problems. But I think the important issue is about how we can stem out the problems of refusal to hire and excessive charging of fares. These are the 2 most serious problems. Last time when I met with the Secretary, I said that if you want to resolve these problems, it's about using an app, so people could only take hires through an app, but they can't just pick up passengers on the street. So it will be more like a car hire service, and it's less of a taxi service, really. Because then people can't refuse hire because they don't know where you're going. And also the app will record the fare charge, so that people can't charge more. Can you come to your question, please, Mr. Chen? Well, I believe this is the only solution to refusal to hire and excessive charging. So what is your view, Secretary? Mr. Deputy, well, the kind of premium taxi service we're considering, it will be very similar to the current taxi service. There will be a fare meter, and but then if it's service as a whole, then they could agree on the fare on their own. But then with premium taxi, because the requirements are higher, so the fares may be higher. And because it will be done in the form of a franchise, so the government as the regulator would have more means at its disposal to ensure service quality. We believe that should allow us to respond to the needs of passengers. Now, with taxis refusing hire or taking a detour, and with all the other irregularities involving existing taxi service, as I answered oral questions some time ago, I explained that the situation in relation to police prosecution and penalties meted out by the court. We can see that there are now more prosecution cases, and police is going to do more to crack down on such activities. Which part of your question has not been answered? Well, he hasn't answered whether he agrees or not, just a yes or no. That is, with an app, then it would be a total solution to the true problems. Mr. Michael Tan, please take your seat. You have pointed out which part of your question has not been answered. Secretary, well, Mr. Deputy, I thought I've answered the questions. Now, Mr. Michael Tan's talked about an app. Yes, we agree we should use an app as far as possible. And on the service arrangement for premium taxi, we will consider the introduction of the latest technology, mobile apps, and so on. We'll take all that into consideration. Mr. Tan Ka-keung. Thank you, Mr. Deputy. On premium taxi service, I support your initial ideas, in particular on 2 points. That is, there must be an employer-employee relationship, and second, that is, the franchise cannot be transferred. I believe that's a good attempt to try to address these issues. But how do we improve existing taxi services? Especially late at night, say a passenger wants to hail a taxi from Hong Kong Island to go across to Kowloon. It's difficult. It seems that many drivers are reluctant to do that. So under the current circumstances, do you have any ideas in mind, Secretary, to address this issue? For instance, the union has suggested late at night, maybe for the free cross-harbour tunnels, there could be a standard toll, including the return toll when the taxi is not carrying any passengers. Maybe that will allow, encourage night shift drivers to go across the harbour. Mr. Tang, I think you've asked a question. Secretary. Mr. Deputy, if taxi drivers refuse hire during the day or at night, it's against the law. Now, of course, we've discussed this issue at the council meeting, at the panel meetings. We talked about law enforcement by the police and more communication with the taxi groups so that we could try to stem out the problem of refusal to hire. Now, Mr. Tan refers to the return toll. Well, the current fare structure is such that the fare is actually cheaper on longer journeys than for shorter journeys. Then for the free cross-harbour tunnels, and you suggested standard tolls at night. Well, it's a matter of the traffic volume on these three tunnels and also the points connected by these tunnels. So we shouldn't just, it's not just a matter of looking at taxis and then maybe taxi drivers will decide which tunnel to take and deciding whether they will take a hire. But the law requires that taxi drivers must not refuse hire wherever the passengers choose to go. Mr. Charles Mock. Now, in the main reply, it said that there are some 18,000 ordinary taxi licenses issued and over 900 are owned by scattered, 9,000 license holders are scattered by, owned by scattered owners. But you're playing with figures. Only 1/3 of the urban taxi licenses are owned by individual owners. The biggest owner actually owns 12.5% of the licenses, and NT is worse. The biggest holder actually owns 24% of the licenses. And you know, at all, you know, these taxi licenses cost over $500 billion in terms of market value. If you don't address this issue and you just want to introduce premium taxi service, you're just going to bring in a new form of monopoly. So I'm worried there's not. It's not a case of overregulation, as Mr. Yick put it. Rather, what I worry is will be underregulation. Now, the government cannot even address the basic issues involving the trade. How will introduction of premium taxi service address the issue? Now, You say you're going to consider renewal license regime and you may link it to service quality. Here, I'm not talking about premium taxis. For the existing 18,000 taxi license, could you consider such reforms as well? Because that is the only solution to address the problem in the long term. Call for quorum, please.
局長。
Secretary. Mr. Deputy, Mr. Charles Kwok mentioned that for some taxi license owners, well, put it correctly, these are the registered vehicle owners of the taxis. If we count the top 10 license owners together, roughly, they account for about 18% of the taxi licenses, less than 20%. But still, that goes to show that the ownership of licenses is rather scattered. And there is also a real constraint in the past. When taxi licenses were issued, they were issued permanently. The government could not retrieve these licenses, so these became private properties. I mentioned in the main reply we could exercise some regulation under the relevant traffic ordinance in relation to refusal to hire or detour and so on. But for other critical elements in relation to service quality, there's very limited we can do under the current framework. Would you do a study of the current law? She didn't say yes or no. Would you do it or not? Secretary? There's nothing we can do under the law, because taxi licenses, once issued, are permanent, and there is no question of renewal. Thank you.
Bill, first reading. Inland Revenue Amendment Bill 2016. Bill